with the rules of the court governing trial. No orders are made as to cost, and the parties are to bear their respective costs, and ruling is entered accordingly.
As the court pleases.
Yes. Okay. So as it is, when are we coming again?
My lord, although I was lost in major parts of my lordship's judgment, but what I was able to gather from the later part that the network allowed me in was the fact that we need to convert our applications to a writ regards to our reliefs number 3 and 4.
Yes.
So that, my lord, apologies, sir. That means our reliefs 1, 2, and 3 were granted by the courts.
Well, okay, I didn't mention that. Didn't I mention it, man?
Apologies, my lord. The network, we couldn't hear my lord at that time.
No, the court is saying that if it was left for release 1, 2, and 3.
Yes, my lord.
Yes, we could have gone on with the originating summons, that is with the procedure that you brought. But when you consider paragraphs 4 and 5, you find out that this whole thing should come by way of complaints. And in fact, it covers all of them. Everything we've included in the
court.
Yes. Yes. Because if it is already obvious, then the court would have just said 4 and 5 to be converted to that. But we cannot make 1, 2, 3 that by the originating summons, because there's so many factors that will come to play in paragraphs 4 and 5, which can be gotten from paragraphs 1, 2, and 3. So yes, it involves all everything. Everything should come under complaints. It should come not under originating summons. Everything should come, by way of complaints. Yes. Okay. So as it is, when are we coming back?
We can file our pleadings regard our writs. Time doesn't begin to run for us in regards to vacation time, but we'll file it as soon as possible, my lord.
I see.
Can we come back, my lord, respectfully next month?
Next month is September. When are we?
Yes.
This is August. September, we are resuming at the end of September, 27th, is it?
Yes, ma'am.
Yes, we are resuming at the 27th, which means effectively the court will start effective sitting in October.
As if so, we can be accommodated respectfully in October, sir.
Okay. So, okay, let us, okay, December, January. This is a 2022 case. Well, assuming you file and save your own side of this matter on them, they will need time
to respond.
Yes, to respond, and you to
like.
Yeah. Okay, so we may not come in October. Do we have November? We don't have November. December. Can we come in December then? Yes. How do you stand in December?
We are open to my lordship calendar, my lord.
Okay. 13th. Okay. 13th December.
As a
Okay.
court, please.
Okay. So this matter is now adjourned to the 13th day of December 2023 for trial. Yes.
My lord, I thought it should be for mention because respectfully, sir, the applicant who is going to be the sole witness is not within jurisdiction. So I was thinking we'll mention having filed and joint pleadings on that 13th, then we'll not take a date for trial.
Yes, I know that's what it should be, but from experience, let us leave it at trial. Because
Okay.
sometimes when we say mention, and some parties may see it is mentioned, they will say the matter is for mention, and let somebody just listen to what they have to say there. But when you say this, everybody sits up.
As a
It
court, please.
doesn't mean that we must hear it that date if everybody is not ready. So let us leave it at this. It is from experience that I'm leaving it like this.
As a
Yeah.
court, please. I'm so grateful, sir.
Okay.
We take the votes of the courts. Yes, sir.
All right.
Yes.
Yes.
Case number NICF/NA 329/2018 between Dr. Idigbe and one, University of Lagos. The Council University of Lagos. 3, the Senate University of Lagos. 4, the Vice Chancellor University of Lagos. My Lord,
Okay. You say, Doctor. It's not you. Sorry, just a minute. This one is not. I'm sure it is. It's ready. It was printed. It was printed. So where could it be? Maybe you check. Council, we're very sorry. It was printed this morning. You know, we print just on the day that the matter is delivered. Yes, yes. So if we can take another one, once they come, I'll take your own. Okay.
Case number NICF/NA 158/2019 between Mr. Martin Idigbe and one, Angover Trust Limited. 2, Angover Terminal Limited. 3, you can see the just.
Okay, appearances in this case.
With profound respect to my Lord,
Yes.
Paul Omaidu, I announce my humble appearance for the judgment creditor applicant.
Okay.
Yes, Your Lordship.
Martin, check.
I'm sorry, Your Lordship, we can't hear. What kind of this thing is it? Please, can the host assist? We can't hear anything from the court.
resolve issues bordering on interpretation of certain portions of the court's judgment. The applicants who maintain that the respondent suppressed the fact that it is the respondent that is indebted to them have themselves not shown whether or not the making of the garnishee order nisi absolute will prevent them from executing the portion or portions of judgment alleged to have awarded a larger sum to them. They are entitled in law to enforce any judgment in their favor. If over 4 years now down the line, after judgment was delivered in 2019, both respondents and the applicants are still unsure of what their entitlements are or what is the actual position of their rights and entitlements based on the judgment of the court, it will be unfair and unjudicious to keep the garnishees restrained in this seemingly uncertainty, or as the case may be, quagmire. Besides, the applicants by order 47 Rule 16 of the National Industrial Court Civil Procedure Rules 2017 were expected to bring their application to vacate or set aside the court's order within 14 days after the order was made or granted. The garnishee order nisi was made and granted on the 28th day of July 2022. The applicants filed this application on 17th day of October 2022, which is over 2 months after the said order was made. The applicants did not deem it fit to seek extension of time to bring the said application for setting aside or vacating the garnishee order nisi. The applicants have not shown evidence of their compliance with the provisions of Order 47 Rule 17 of the extant rules of this court. No leave of court was sought. No order for extension was made. No evidence of payment or default fees for not applying for setting aside of vacation within 14 days was made available. Rules of court are not for fancy. They are meant to be obeyed, complied with. This is so because there will be no other judicial process where the rules governing the processes are not obeyed or where parties are free, for example, to seek relief from a court as they wish and in their own style without any regard to the rules providing for the procedure which a relief could be sought in the court. See the case of Stowe versus Benstowe, reported in 2012, Adamu and State. out by the rules of court or exercise its discretion favorably to them by extending time is fatal to their own application to set aside the Ganishi order 9 In the light of the proceeding, this court finds and holds that given the non-compliance by the applicants, this application is incompetent. The issue for determination is thus resolved in the negative against the applicants, and the applicant's application is hereby struck out. I so find and hold. Now, moving on, where the Ganishi does not appear or appears but does not show cause why he should not be ordered to pay the judgment sum to the judgment creditor from the account of the judgment debtor, his possession, then an order absolute would be made against him. In view of the deposition of the first Ganishi, First Bank of Nigeria Limited, in his affidavit showing cause of 23rd day of August 2022 at paragraph 3, that there is sufficient credit balance in the account of the third applicant to cover the judgment sum of 151,000 naira only. The Ganishi order now is hereby made absolute. The first Ganishi is hereby ordered to pay into the account of Mr. Martin Chijoke Agude the said judgment sum of 151,000 naira only. And I so find and I so hold. Yes, that's the ruling of the court and it is entered accordingly. Yes.
As the court pleases.
Okay. Well, I guess that closes that case because if the orders of the court are carried out, there is no more to this matter. Isn't it, Mr. Paul?
Yes, Your Lordship. For
Okay.
now, except that we will consider our options, Your Lordship.
Very well. Okay. So this particular process is adjourned sine die.
As Your Lordship pleases.
Yes. Okay. Have you printed it? Where is it?
Number NIC of Blanche Ellis of 3.9% between Dr. M. Koyo and once University of Lagos. The country University of Lagos. For Vice Chancellor, University of Lagos. My Lord, passes are absent.
Okay. Appearances? Yes. Okay. Okay. Is there any other person?
With due respect to my noble lords,
Yes.
my name is Angela Okodua, and that's my parents for the defendants.
Okay. Okay. Do we agree that I adopt the same method like the other ones, because I still have many more rulings to make? Do I just read out the
Yes, my lord, as the court
resolution?
pleases.
Okay. Now I go straight to the resolution. Yes, having regards to the facts and circumstances of this suit, the process is filed by the parties herein with respect to the instant application, the submission of the counsel on both sides. This court distills the issue below for determination, and that is to say, is there merit in the applicant's application under consideration? The learned counsel to the claimant respondent contends that the instant application is a misfit, as the issues herein ought to be raised by a motion on notice. Besides, the applicants are by the instant application attempting to use the back door to buy time and respond to the claimant's application of 10th March 2022. The applicants on their own part contend that Order 17 Rule 1 to 9 of the National Industrial Court of Nigeria Civil Procedure Rules 2017 permits them to raise an objection, and that notices of preliminary objections are used primarily to challenge abuse of court processes. The claimant filing two distinct replies to their statement of defense is an abuse of court process, he added. While I tend to agree with the submissions of the learned claimants counsel to the defendant applicants, that the defendant applicants ought to have filed an application by way of motion on notice and not the one termed notice of preliminary objection, or raised the issue of abuse of court process in their counter affidavit and written address in respect to the application of 10th March 2022, may I quickly note that none of the parties are in doubt that the instant application simply challenges the competence of the claimant's replies to the first to fourth defendant's statement of defense and the application of 10th March 2022. A procedure, I must say, is accommodated within the confines of the rules of court. Order 5 Rule 2, 1 and 2 of the National Industrial Court of Nigeria Civil Procedure Rules 2017 allows a party who is of the opinion that the adverse party's alleged failure to comply with any provision of the rules is such an irregularity that makes the proceedings or further proceedings defective to apply to court by an application to set aside for irregularity any step taken in the course of the proceedings after becoming aware of the irregularity and before taking any fresh step. The said Order 5 Rule 1 and 2 of the NICN Civil Procedure Rules states, and I quote, 1, Rule 1 says, failure to comply with any of these rules may be treated as an irregularity, and the courts may give any direction as it thinks fit. Then 2 says, an application to set aside for irregularity any step taken in the course of the proceedings may be allowed where it is made within a reasonable time and before the party applying has taken any fresh step after becoming aware of the irregularity. 2.2 says, an application under the rule may be made by summons or motions, and the grounds of objection shall be stated in the summons on notice of motion, unquote. From the provision of Order 5.2.2 of the NICN Civil Procedure Rules 2017, above recited, it is clear that the defendant applicants ought to have brought this application by way of summons or notice of motion, and not by way of notice of preliminary objection. Be that as it may, it is settled law that the days of technical justice are long gone and buried. Since both parties and the court inclusive are not in doubt as to the intentions of the applicants, that is, they intend to challenge the purported incompetence of the claimant's two separate replies to their statement of defense and the application that seeks to regularize the second reply to the first to fourth defendant's statement of defense. It will be toiling the line of technical justice to find and hold that, given the fact that the application is headed notice of preliminary objection and was not brought by way of summons or notice of motion, it is incompetent. Had the defendant applicants proceeded to file a counter affidavit and written address in opposition to the application of the 10th of March 2022, it might have been interpreted as taking a first step, which would mean they had forfeited their right to apply, that the observed irregularity be set aside. The law is not a game of hide and seek. Both counsel as ministers of the temple of justice have a duty to be candid and fair in their dealings with the court and one another. Just as parties are bound by the records of the court is also bound by its own records. The defendant applicants have drawn the attention of the court to the purported irregularities surrounding the claimants filing two separate replies to the first to fourth defendant's statement of defense in an alleged bid to substitute the latter with the former. The claimant has not outrightly denied this allegation, but rather insists that the earlier filed reply to the first to fourth defendant's statement of defense was filed without his express instruction or contrary to his express instruction by his former counsel, so it does not bind him. It is very well in order to point out that the defendant applicants acted within the confines of the law and the rules of proceedings or practice in this court to bring the instant application through wrongly labeled or categorized. The rules of practice permits the applicants to challenge the competence of a process or bring an application seeking to set aside step taken in the course of proceedings that is irregular. The claimant respondent's objection to its consideration are hereby overruled and discountenanced, I so find and hold. Now, the claimant is, as noted earlier, is of the view that the earlier filed reply to the first to fourth defendant's statement of defense did not represent express instruction from the claimant. Funny as it seems, the first claimant's reply to the first to fourth defendant's statement of defense was filed on the 22nd day of January 2020 with leave of the court, though actually filed on the 13th January 2020. Then on the 23rd day of March 2020, the claimant's counsel filed an application for change of counsel. On the 30th day of September 2021, the claimant filed another reply to the first to fourth defendant statements of defense without applying that the earlier reply be withdrawn and struck out or applying to amend the earlier file reply to the first to fourth defendant's statement of defense. This is clearly an abuse of the process of the court. If there is any truth in that the claimant's former counsel did not heed his express instruction, which from the first before the court not only appears improbable, but also preposterous, given the timeline and sequence of events, assessing them from the point of view of a reasonable man, even taking into account the timeline of the COVID-19 lockdown. May I, as a word of caution and advice to counsel, state that it is often said, and I quote, "What is good for the goose is good for the gander," unquote. For when a legal practitioner, for whatever reasons, permits a client to make disparaging remark about his colleague, who from the face value of things acted bona fide and in the client's interest, it is only a matter of time before such legal practice reaps what he has sown or permitted to be sown using his practice. A word is enough for the wise. This is not to condone any untoward behavior by legal practitioners or conduct unbecoming of a professional. Yet one can glean from the records of the court that after leave was granted to the claimant to file his reply to the first to fourth defendant's statement of defense on the 22nd day of January 2020, there is nothing to show that the claimant filed an affidavit or protest to contest that the said process was not in his interest or born out of the express instruction of his counsel, or that his previous counsel acted malafide in filing the said process. Even when he changed his counsel about 2 months after, the claimant did not deem it fit to notify the court of whatever alleged complaint he had about the conduct of his previous counsel. 13 days short of making it exactly 2 years after filing an application for change of counsel, a claimant in an affidavit not deposed personally by himself attached a lengthy letter supposedly protesting the conduct of his previous counsel. May I quickly point out that the claimant's second reply to the defendant's statement of defense was filed on the 30th day of September 2021, about a year after the lockdown was lifted, a year and about 6 months after the application for change of counsel was filed, almost 7 months after filing the said second reply, after filing the said second reply to the defendant's statements of defense. The claimant appears to have woken from his slumber, and same was filed out of time, and there was need to file an application for extension of time, giving rise to the claimant's application of 10th March 2022. The court is bound by its records and is not conjectures that because some court staff were informed, the court is in the know of what transpired between the claimant and his previous counsel. The sacredness of the court as a temple of justice must not be told with either by litigants or by their counsel. I have said enough on this. Now, an abuse of court process is a misuse of or improper use of the process of the court to the annoyance, irritation, or oppression of the opposing party in such a way that hinders the efficient and effectual administration of justice. See the case of Usman versus Baba, reported in 2005, 5 Nigeria Weekly Law Report, Part 917, page 113. If the earlier file reply to the defendant's statement of defense did not capture all that the claimant wanted to impress on the court in build-up of his claims, it is well within his right to approach the court to seek an amendment of the said process. For reasons best known to the claimant, it appears he felt it was not time to exercise the right. It also seems that the claimant had no problems with all the other processes filed by his previous counsel, save the reply to the defendant's statement of defense. The claimant, with due respect, cannot eat his cake and have it by contending that the reply is not binding on him. filing two separate replies to the first to fourth defendant's statement of defense without seeking amendments for the one first in time or applying to court to have it withdrawn for whatever reason means that the second reply to the first to fourth defendant's statement of defense filed by the claimant affects the efficient and effectual administration of justice. It was filed to the irritation and probably annoyance of the defendants, making the latter reply to the statement of defense an abuse of process of this court, which is liable to be struck out and is hereby struck out. I so hold and I so find and hold. Similarly, the claimant's application by way of motion on notice, dated the 10th day of March 2022, filed on the 14th of March 2022, seeking extension of time to regularize the claimant's reply to the statement of defense filed on the 30th September 2021, would not have anything to stand on. As one cannot place not something on nothing and expect it to stand. The process it seeks to regularize having been struck out, the claimant's application of 10th March 2022 will have no utilitarian value. It has become odious. It is accordingly struck out, and I so find and hold. Yes, in all, the issue of for determination is resolved in favor of the defendant applicants. The claimant's reply to the first to fourth defendant's statement of defense of 30th September 2021 and his application by way of motion on notice on the 10th of March 2022, filed on 14th March 2022, having been found to constitute an abuse of the process of this court, are in the interest of justice hereby struck out, and I so hold. There is no others to cause. Parties are to bear their respective costs. Yes. Yes. And I know you of course, you know what's played out. Okay. Okay. Thank you. So, okay. We had just finished the did we really finish the defense? Okay. This is the preliminary objection we've just done. Okay. Where do we stand in the case proper? Mm. Yes. Okay.
Progress from them a lot.
All right.
Because as it is now,
Yes.
we may have to come back with an application to amend the reply so as to do the needful, sir.
All right. Do you have any date in mind? Ms. Angela,
Yes.
you can approach him. Think about the date.
Well, my lord,
Agree on a date, or
now we come back.
and because I see that this is a fairly old case.
Yes, my lord, that's what
Okay.
I'm saying, that from what I've heard from your lordship's previous statement, that maybe we can come back in October, if or because your lordship will be resuming at the later part of the next month, which is September. We can come back on any convenient date to your lordship diary for October for mention.
I've seen my girl's head shaking vigorously.
Then if October, no, it's for mention. If October
Okay.
is filled up,
9th of November.
as the court, please.
How do you stand? Okay.
As the court, please. We'll take it, sir.
Registrar, please, we can't hear anything.
Yes, there's a network issue from my Lord's side. They are trying to connect back. So sorry for the inconvenience.
No problem. Thank you.
All right, sir. Sincere apologies, sir. We can hear you. It's okay. My Lord can use that one.
No, where's it?
That was the one that you said reference for change.
Says, listen, let me read it. It's not on. It's not
Please, my lord's audio is muted, please.
Call 2, please unmute my Lord mic. Thank you. It's working now.
Okay. You're hearing my voice now.
Yes, my Lord. Yes, my Lord.
Okay. I'll put on this. Very well. Very well. So, Mark has just called up case number 17/2022. That is Mr. Fashola. Appearance.
Respectfully, my lord, my name is FBI Oyewale, my lord. I humbly announce my appearance for the claimant.
Okay. For
the claimant, my lord.
Okay. Yes. Go again. It's on the other side. Oh, Mary. Okay. I take it that there's nobody for the defendant. Defendant not represented. Okay. FBI. Mr. FBI. So Yewale. Oh, Jesus.
My lord, I can hear you, my lord.
Mr. Yewale, are you hearing me now? Are you hearing me?
Yes, my lord, I can hear you clearly. Yes, my lord, I can hear you clearly.
I want, because of the number of matters we are going to rule on, I don't know if it's all right with you for me to read out the resolution, since you are going to have the ruling itself. Are you hearing me?
Yes, my lord, I can hear you. No problem. That's fine, my lord.
FBI?
That's fine, my lord. That's fine, my lord. I can hear you clearly. My lord, I can hear you. I can hear you clearly. That's fine. My lord can go ahead to just read the resolution.
Yes, can you hear me now?
Yes, my lord, I can hear you clearly. Can you hear me?
Yes, I can hear you.
Okay,
So I was trying to tell you that given the number of rulings and judgments that I've done and I'm still going to do, I want us to start from the resolution, since I'm going to have the.
Well understood. Well understood, my lord. Yes. My lord can go ahead with the resolution and then we get the ruling. So yes. It's fine, my lord. It's fine, my lord.
Very well.
Thank you, my lord.
Yes. Let me see if this is the railway, Nigeria Railway. Okay. So the resolution, giving consideration to the facts and circumstances of this suit, the process filed by the parties herein, the submissions of counsel in support and in opposition to the grant of the instant application. This court distilled the issue below for determination, and that is, do paragraph 7, 21, and 22 of the first defendant statement of defense of 26 April 2022 conform to the rules of pleadings? The claimant applicant contends that the first defendant's statement of defense, particularly paragraph 7, 21, and 22, offend the rules of pleadings as they contain decisions of the Supreme Court, and pleadings should contain facts and not law. The first defendant respondent on his own part argues that parties are in their pleadings permitted to raise points of law therein. Paragraph 7, 21, and 22 of the first defendant's statement of the denial rebuttal of claimant's statement of facts reads, and I quote, paragraph 7, the first defendant denies paragraph 2 of claimant's statement and avers that it is not an agency of the federal government. Instead, the first defendant is a corporate business entity created by statute to undertake the business of transportation by rail to carry out all other functions ancillary to its core business. The first defendant shall rely on the locus classicus of the Supreme Court in Federal Mortgage Bank of Nigeria versus Olo, reported in 2002. Citations supplied.
Sir, your own is causing the issue. I don't have issue. I will take you back. There's a conflict. Yes, there's a conflict now. You go off. My lord will not hear from my lord again. My lord will go off. So this one she's using is okay. So sorry, my lord. My lord is okay.
Okay. Now, paragraph 21 says, the first defendant denies paragraph 13 of the claimant's claim and says that the National Incomes and Wages Commission circular, reference number SWC/S/04/S300/1, does not apply to the Nigerian Railway Corporation, which is neither a parastatal nor an agency of the government. The defendant invokes the decision of the Supreme Court in the case of Federal Mortgage Bank versus Olo, Supra. In further response to paragraph 13 of the claimant's statement of facts, first defendant further placed reliance on the letter of 28th day of October 2015, where it clearly stated that, quote, the computation of their gratuity is therefore based on their respective status and the applicable salary structure that subsisted as at 2002 and not otherwise, unquote. Then paragraph 22 says, the first defendant shall also formally rely on the case of Nigerian Airways Limited versus Okutubo, reported in 2002, citation supplied, where it was held that the federal public service rules or circulars based on them can only become relevant in consideration of a contract of employment where it was expressly or by necessary implication contemplated in the letter of employment. The first defendant will challenge the claimant to show where in his letter of employment it was contemplated that his condition of service would be affected or governed by such circulars as the one pleaded by him. It is clear from the reproduced averments in the first defendant's pleadings that the first defendant not only made reference to certain decisions of the Supreme Court, but also produced excerpts of part of the decisions. Order 30 Rule 3.1, Rule 4, Rule 8.2 of the National Industrial Court of Nigeria Civil Procedure Rules 2017 provides thus 3.1, every pleading shall contain a statement in summary form of the material facts on which the party pleading relies for the party's claim or defense, as the case may be, but not the evidence by which they are to be proved, and shall, when necessary, be divided into paragraphs and numbered consecutively. Paragraph 3.4 says, the fact shall be alleged positively, precisely, and distinctly, and as briefly as is consistent with a clear statement. 8.2 said, where a party raises any ground which makes a transaction void or voidable, or such matters as limitation law, release, payment, performance, facts showing insufficiency of the contract of employment or illegality, either by any enactment or by common law, the party shall specifically plead the same. While Order 30 Rule 82 of the NICN Civil Procedure Rules 2017 lends credence in part to the position canvassed by the Learned Counsel to the first defendant respondent. Order 30 Rule 3.1 and 4 of the rules of this court is categorical that what a party's pleading should contain is statement of material facts which a party relies on for its claim or defense and not evidence. The rules of pleadings are in place largely to safeguard the rights of fair hearing. Also, it reduces the element of springing surprises by litigants, making the identification of the cause of action easier, which by implication means that a party is bound by his pleadings and cannot make a case different from what he has set down in his pleadings. See the case of Trade Bank PLC versus Pharmatex Industry Limited, quoted in 2020. UBA PLC versus Vetex Agro Limited, quoted in 2020. Citations supplied. It was held inter alia that generally pleadings contain facts, not law. Most rules of courts contain provisions stating this general principle of law. See Nwadia Law versus Shell Development Company Limited, reported in 1990. 5 Nigeria Weekly Law Reports, Part 150, page 322. And also SPDC versus Burutu, LGC, Local Government Council, reported in 1998. Citation supplied. Rules of courts on pleadings, like Order 30, Rule 3 of the NICN Civil Procedure Rules 2017, require a party to state concisely in numbered paragraphs the material facts of his case, which he relies on, but not the evidence with which those facts are to be proved. See Honor versus Schlumberger, Nigeria Limited, reported in 2018. The approach taken by the Learned Counsel to the first defendant respondent, in my considered view, transcends raising a point of law in a party's pleading. The fact that a party is permitted to plead, or rather raise issues of points of law, like statutes of limitation, does not translate to including decisions of a court on the said issue, especially when the cause of action is not one that calls for interpretation. I cannot agree less with the submissions of Learned Applicants Counsel that if the first defendant respondent felt a strong need to raise in his pleading issues of law, it ought simply to have pleaded material facts in relation to the law, decision or principles it desires the court to take cognizance of, rather than cite the said decision in its pleadings. It is the duty of counsel who settles pleadings and adhere strictly to the rules to be observed when drafting pleadings. Failure to observe the rules will necessitate the striking out of the pleadings. See the case of Ama Jideogu versus Ononaki, reported in 1988. Citation supplied. The fact that the applicant drew the attention of the court to this issue does not, in the considered view of this court, amount to an abuse of the process of the court, as it is such an issue of law that the court can raise suo motu. The first defendant respondent should be thankful that it was raised timeously, affording it the opportunity to, if need be, amend its pleadings. In law, there is a distinction between pleading law and raising a point of law in pleading. Pleading law could have effect of obscuring or concealing material facts of the case, making the pleading contain arguments which is not permitted while raising a point of law, isolates an issue of question of law of the facts pleaded. In other words, raising a point of law in pleading has the effect of drawing the court and the opposing party's attention to the isolated issues or questions of law founded in the pleadings, given the facts pleaded. At paragraph 7 and 21, the first defendant who pleaded facts almost concealed and or obscured the facts by citing the decision of the Supreme Court in the said paragraphs. Paragraph 22 of the first defendant's statement of denial rebuttal to the claimant's statement of facts with the pleaded law appears more like an argument to be impressed on the court at address stage. The fact in relation to the letter of employment not containing certain facts has been obscured by the pleaded decision of the Supreme Court therein. Part of the rationale behind not permitting parties to plead law simpliciter is that the practice of courts is to consider and deal with the legal results of pleaded facts, although the particular result alleged is not stated in the pleadings. See the case of Auto Import Exports versus Adebayo, reported in 2005. I think the interest of justice would ordinarily demand sieving the wheat from the chaff, such that the material facts pleaded at paragraph 7 and 21 of the first defendant's statement of denial rebuttal to the claimant's statement of facts be separated from the portions where the law was pleaded minutely, but the tidier thing to do is for the first defendant to do the needful. This court thus finds and holds that certain portions of paragraph 7 and 21 of the first defendant's respondent's statement of denial rebuttal to the claimant's statement of fact of 26th day of April 2022 offends the rule of pleadings as they are pleaded law, which is not permitted. Also, that paragraph 22 of the first defendant's respondent's statement of denial and rebuttal to the claimant's statement of fact offends the rule of pleadings as it is pleaded law and is more of an argument. In the light of these findings, the issues for determination is resolved in the negative, and paragraphs 7, 21, and 22 of the first strike rebuttal to the claimant's statement of facts are hereby struck out. I so find and I so hold. There is no other meant as to costs. Parties are to bear their respective costs, and ruling is entered accordingly.
Thank you for a well-considered ruling, my lord. We're very grateful for that, my lord. Thank you so much.
Thank you very much. So, when do we come again then? Mary,
Yes, my lord.
give us a date.
Information of
Well, let me see. Before this ruling, it was for. Okay, it's for hearing because we've just been dealing with the motions. It is for hearing.
and we are moving to January, my lord.
I understand we don't have a date until January for trial. What do you say? Yes.
Okay, my lord. If that is the case, man, I was thinking it would be scheduled for mention, but since it's now trial, would go with the date in January.
Okay. Because if the way things are now, we bring a case for mention, maybe on that day, I don't know. You prefer, okay, what of mention?
November 9.
Okay. What do you say if we come by 9th November for the mention you said, and then we now take a clear date for trial when we sort out
Yes,
all this?
yes, my lord. That's fine, my lord.
November 9th is good for both of you?
My lord, I can only speak for myself. I mean,
Okay.
since the defendant,
Okay, yeah, yes, okay.
the defendant is not in court,
Yes.
my lord.
No, okay, for mention. Okay. Hearing notice to be served on the absent. So this matter is now adjourned to the 9th day of November 2023 for mention. And this ruling is now the hearing. This day is to be okay. This this date is to be served on the absent defendant to that effect. That is the fact that it should come, and we will mention, the matter and take a date for hearing. Is that all right with you? Is that all right with you?
So depending on.
Mhm.
Case number NICN/LA/381/2021 between Mr. Daniel Etim Inyon and Waste Care Solution and Resources Management. My lord, parties are absent.
Okay. Appearances, please.
With the greatest respect to my lord,
Yes.
my name is F.D. Olorun Motoba. My humble appearance is for the claimant.
Okay.
With profound humility.
Yes.
Yes. My name is K.O. Oboy, appearing for the defendant. K.O. for initials, Oboy spelled O-B-U-E.
All right. Okay. For the defendant. Please, for want of time, there are so many rulings because they've been accumulating. I guess it will be better if we start from the resolution, since we are going to have the entire ruling. Let me just read out the resolution, and then we they now give you the entire ruling. It's already ready.
Very well, my lord.
As the court pleases, my lord.
As the court
Okay.
pleases.
Very well. Thank you. So, the resolution now. Having regard to the facts and circumstances of this suit, the process is filed therein in support and in opposition to the grant of the instant application. The court distills the issue below for determination, and that is, has the claimant applicant complied with the rules of this court, and is his application such that the court can exercise its discretion favorably to us in the light of the facts emanating therefrom? As rightfully pointed out by counsel on both sides, the grant of an application of this nature lies at the discretion of the court, which discretion must be exercised judicially and judiciously. The claimant applicant, by the instant application, seeks an order of court granting it leave to amend his general form of complaint and other accompanying originating processes. In this suit, as per the attached amended complaint, and a deeming order is a deeming order. The defendant's respondent contends that the applicant who proceeded to amend his complaint without the leave of court is in violation of the rules of this court. Rules of court are meant to be obeyed, and the failure to obey the rules regarding amendments makes the process amended defective and liable to be struck out. No doubt, the law is well settled that rules of court are not for fancy. They are meant to be obeyed. They guide the procedures and practices of parties before the court in the conduct of their case, and it is not open to parties to adopt whatever is convenient in their disregard to the provisions of the rules of court. The provisions of Order 26 Rule 1, 2, 3, and 4 of the National Industrial Court of Nigeria Civil Procedure Rules 2017 are clear and unambiguous. They are to be given their plain, ordinary, and natural meanings. It's the fact that the document marked as Exhibit A, attached to the applicant's supporting affidavit, does not have the word proposed thereon, but the amendments proposed were supposedly underlined. This in effect means that the respondent and the court are not in doubt as to what portions of the process is what the applicant intends to amend. The respondent has not shown what damage or injustice would be occasioned to it if by the applicant's failure to include the words proposed on Exhibit A. As much as rules of court are meant to be obeyed, they are not to be followed slavishly or in such a manner that will occasion, inflict, or impose injustice on parties. Just as the learned Respondents' Council noted, the days of technical justice are long gone and buried. They should not be resurrected for whatever reasons, nor their tombstones visited to commensurate with them. Part of the rationale behind the provisions of the rule is to ensure that the opposing party, the court, and a reasonable bystander are not in doubt as to the amendments sought are all about, and to preserve the notion that application for amendments are not granted as a matter of course. The court, as an unbiased arbiter, will consider the merits of the application vis-a-vis the facts of the case and decide one way or the other on the application. Besides, Order 5.1 of the NICN Civil Procedure Rule 2017 categorical that failure to comply with the provisions of the rules will be treated as an irregularity, and the court may give directions as it deems fit, which by Rule 3 of the same order includes a departure from the rule in the interest of justice. I do not think the defendant respondent has been misled as touching the nature of the amendments sought by the claimant applicant, which were clearly underlined, or that the respondent has suffered any injustice or harm by reason of the applicant's failure to include the word proposed on Exhibit A. Whatever defect or irregularity arising therefrom are, in the considered view of the court, not such that affects the merits or substance of the instance suit. In the interest of justice, the said document can be looked into by the court. I so find and I so hold. On the issue of filing the amended complaint without leave granted by the court, a defense counsel contends a defect that the defense counsel contends cannot be cured by a deeming order. The learned counsel to the defendant respondent did not support this leg of his submission with any statutory judicial authority. The purpose for seeking leave is, amongst other things, to prevent parties from taking matters into their hands and at will amend their processes without recourse to the court, and giving notice to the opposing party so as not to infringe on its rights to fair hearing. The aim of deeming orders is in relation to applications for amendment is amongst others to avert unnecessary delays in proceedings. The fact that a party has filed an amended process for which leave has not been sought and obtained does not necessarily make the process competent. The court is determining the merits of the application for amendment may decide otherwise and do the needful. It will therefore be important to look at the reason given by the respondent for its alleged incompetence before reaching a decision one way or the other. In the case of CBN versus Benin reported in 2001, citation supplied, the Supreme Court held inter alia, and I quote, amendment of pleadings are ultimately to enable the court to decide the real issues in controversy between the parties. It is to prevent the court from giving judgment in ignorance of the facts and should be known before the rights of the parties are finally decided, unquote. Usually, amendment of pleadings is granted when it will not necessitate the calling of additional evidence or change the character of a suit. See Anekwe versus Oladeji, reported in 2008. An application for amendment can be granted at any stage of the proceedings. The burden is on the party opposing the grant of the amendment to pleading to show why the amendment should not be granted or that the application was not brought in bad faith. See the case of Amanso versus RTBTC, reported in 2009. The Learned Respondents Council has contended that the amendment sought by the applicant has introduced new facts, changed the nature of his claims, and will shut it out. It does not appear that the respondent did not avert his mind to the fact that a grant of leave to amend the applicant's originating processes and pleadings does not foreclose his right to make consequential amendments to his statement of defense. And when the applicant files a reply to the amendment statement of defense, a rejoinder, be it as it may, it is clear from the underlined portions of the document marked as Exhibit A, attached to the supporting affidavit, that there were new facts introduced at some portions, a number of which were clear responses to the facts averred in the defense respondent's statement of defense. It seems the approach the claimant applicant has taken is to seek leave to amend his originating processes and pleadings, and where this is his application is granted and the defendant makes consequential amendments, he can explore his right to file a reply to the amended statement of defense, thus taking a second bite at the cherry, or put differently, eat his cake and still have it. This obviously does portend that his application was not brought in good faith, or such that this obviously does portend that his application was not brought in good faith, or such that it deprived of anything that will unfairly prejudice the defendant's respondent. In law, the court is at liberty to decline leave for amendments to pleadings when the application is brought in bad faith. Will it in any way unfairly prejudice the opposite party, would cause unnecessary delay, is quite irrelevant or useless, or would merely raise technical issues? See the cases of Okafor versus AP Nigeria Limited, reported in 1996, Akpan versus OATRC, reported in 2015, and also Okolo versus UBA, reported in 1999. Citations are supplied. If the claimant applicant felt the defendant raised new issues that should be addressed in his statement of defense, it is within his right to file a reply to statement of defense. If for whatever reason he felt doing so would have created inconsistencies, in his pleadings on the nature of his claim. Filing the reply will not foreclose his right to amend his complaint and statement of facts. Using the medium of an amendment to try to achieve this would appear that the intention of the claimant is to outwit the defendant, display a degree of smartness to frustrate the defendant. In the case of NIWA versus SPDC Nigeria Limited, quoted in 2008, the Supreme Court, Penikitobi JSC, defined the words and phrases overreach and overreaching conduct to mean, quote, overreach means to circumvent, outwit, or get the better of something by cunning or artifice. It also means to defeat one's object by going too far. It connotes smartness on the part of a party in the litigation to defeat his opponent by a thoroughly organized plan to frustrate the intention and intendment of the adverse party. An overreaching conduct is an inequitable conduct because it is not fair and just, unquote. Such conduct by the claimant applicant is capable of putting the defendant at a disadvantage. Having gone through the proposed amendment as underlined in Exhibit A, and noted that the facts introduced by the claimant applicant are mostly responses to the allegation facts in the defendant's statement of defense, this court is of the considered view that the instant application is unmeritorious, as the amendments sought are such that may unfairly prejudice the defendant, frustrate its intentions. Accordingly, they are hereby refused, and it will be injudicious to grant them. See Order 26 Rule 12A of the National Industrial Court of Nigeria Civil Procedure Rules 2017. Having found the instant application to be lacking in merit, same is hereby refused and accordingly struck out. The next claimant's counsel submission in respect of same are hereby discountenanced. So I find and so I hold. And that is the ruling of this court. Yes. Yes. There is no cost. There's no others as to cost, as the parties are to bear their respective costs.
As the court pleases.
Yes.
We are very grateful,
As the court pleases.
Your Lordship, for the well-considered
Well,
ruling. We can see a whole lot of weight of wisdom being put into this ruling. Thank you very much. And we pray that God will continue to grant you more wisdom to dispense justice. Thank you, Your Lordship.
My Lord, we are equally very grateful for that well-considered judgment, or ruling, rather, my Lord. Yes, my Lord.
Okay.
My Lord, as it stands, may we take a date for trial?
Yes, we will definitely do that. But I'm reliably informed by my crew here that any matter for trial will have to go to January because of the lineup of old cases, old 2013, 2015, 2012. So we line them up so that we dispense with them. From January, this will be one of those ones that will quickly go because they are new and the parties are still interested in the case. That is the beauty of it. So how do you start in January?
All right, my Lord, I will, on that note, I will want to appeal to the court. The court to give, if the court cannot, we just have one witness, and I believe the claimants also have one witness, or come from outside jurisdiction. I want to appeal to the court, if the court can give us 2 clear days, so we'll take the claimant case, and the next day we'll bring forth our witness and finish up the case.
Okay, we are talking about January. Eh?
No problem. It's very okay, Your Lordship.
Okay, if you want January, actually, if you want 3 days, we can give you. If you
As
want,
the court pleases.
If it is January, we'll give you 2 days if you like.
As the court, we'll be so grateful.
Is it consecutive, or you want them apart? Do you want 12th and
my lord, I
13th
think it will be
or 12th and 18th?
my lord, we want it consecutive
23, 24. You want it consecutive.
as the cup.
Okay, how do you
For
start?
me, consecutively
All right.
will be
20,
23rd and
23,
24th.
24.
21
Yes.
Oh, it's
Yes.
convenient. 23rd
Very
and
well.
24th January.
23.
It's convenient for us.
Okay.
23, 24th. My lord is equally convenient. Those dates are convenient.
Okay.
All right. So are we going this way? The claimant case 23rd, the defense 24th. I believe that's the way we are going.
I'm hoping so too. I'm hoping that's
all right.
the way to go. So the matter
right,
is going to be 23rd and 24th days of January 2024 for definite trial.
As the court pleases.
Yes. Yes. Thank you.
Thank you very much. God bless you, Your Lordship.
As it go. We are grateful.
Thank you. Thank you very much. Yes. Thank you. Okay.
Case number NICN/LA/72M/2022 between Festus Oluchi Okpara and Towa Aluminium Nigeria PLC.
No.
Respectfully, my lord.
Okay. Appearances?
OF, respectfully, my lord.
Yes.
OF Udebwani. OF initials Udebwani is UDEBUANI, appearing for the judgment creditor / respondent.
Okay. Yes.
Humility to this court.
Yes.
Nene Oze. Nene is Nene. Oze is OZEH.
Yes.
For the party affected applicants.
Okay.
Respectfully, my lord.
Yes.
AC Nick Abugu. My lord, Nick Abugu is spelled NICKABUGU for the 19th guarantee, Standard Chartered Bank Nigeria Limited.
Okay. Yes. Okay. We have only one garnish in this matter. Do we?
Yes, my lord. The matter is for ruling today.
Yes. All right. Please. Because of the number of cases that we have, the ones that we have ruled on and judged, and the numbers that are still remaining, I won't start this from the beginning and end it because there will be no time. Jesus. Okay. So are we agreed that since you are going to have a copy of this, everybody is going to have a copy? Do you agree that I should read the end part of it?
As the court pleases.
As the court pleases.
As God please, my lord can go ahead with the resolution.
Okay. Jesus. But it was 11 o'clock. Okay. The court will start from its own paragraph 35. This is quite long. It's a long ruling. So, but I will start from somewhere. Later, you will get everything. Now, irrespective of what comes before this, it appears that the applicant is being economical with the truth, as it downplays the fact that prior to the judgment debtor going into receivership, its management or directors had the power to appoint any legal practitioner to defend the company's interests in any legal proceedings, and such contracts entered into by the company before his appointment as a receiver is binding on him. See the case of Babington Ashaye versus EMAG Enterprise Nigeria Limited, reported in 2011. Citation supplied, where it was held, and I quote, contracts entered into by a company before the appointment of a receiver or manager are binding on him. Thus, a receiver or manager cannot renounce a contract entered into before his appointment. See also the case of Tanarewa Nigeria Limited versus Plastic Farm Limited, reported in 2003. Now, the power conferred on the applicant by virtue of item 5 of the 11th schedule of KAMA and paragraph D of the deed of appointment of receiver manager to bring or defend any action in any legal proceedings does not translate to the power upon appointment to automatically rescind or renounce all prior contracts entered into by the judgment debtor. Besides, it is glaring from the applicant's affidavit evidence that it was one of such contracts, the trust debenture deed, that gave rise to his appointment as receiver manager. This power does not, with due respect, also translate into imposing on the court a mandate on the receiver separately from the counsel on record the processes of the court in an ongoing proceedings. Any restriction of a company whose assets are under receivership to institute an action in court only relates to the assets in receivership. It does not extend to other assets or other matters affecting the company. See OBI Limited versus UBN PLC, reported in 2009. Citation supplied. An application to set aside or vacate calls for the exercise of equitable remedy. And it is the law that equity is the vigilant and not indolent. He who comes to equity must come with clean hands. As rightly pointed out by learned counsel to the judgment creditor respondents, sections 559 sub 1b and 560 of KAMA 2020 mandates the directors of a company under receivership upon appointment of a receiver manager to furnish the receiver with a statement as to the affairs of the company, which includes, among others, particulars of the company's assets, debts, and liabilities. One of such liabilities is claims arising from pending claims in legal proceedings. See the case of Ekeng versus Polaris Bank, Supra. The applicant nowhere in his affidavit in support of his reply affidavit alluded to the fact that the directors of the judgment debtor failed, neglected, and or ignored to furnish him with such particulars, including notice of proceedings in suit number NICN/LS/16/2017, or that the applicant formally wrote to the counsel on record who entered defense for the judgment debtor to discontinue his appearance, and he failed to do so. Equity sees as done that which ought to have been done. The records of this court, which binds the court and the parties hearing, reveal that the law firm of Judge Taylor, Ashiru and Co. kept receiving hearing notices and other processes in suit number NICN LA 16/2017, though no counsel was appearing in court from the firm after a while, which nevertheless can be interpreted as a holding out that their services were returned by the judgment debtor. Section 169 of the Evidence Act 2011 states, and I quote, when one person has, either by virtue of an existing court judgment, deed or agreement, or by his declaration, act or omission, intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, neither he nor his representative in interest shall be allowed in any proceeding between himself and such person or such person's representative in interest to deny the truth of that thing. The conduct of the counsel from the law firm that entered appearance for the defendant judgment debtor. The applicant who waited for almost 3 years, short of a month, to approach the court to bring to the notice of his appointment as a receiver, with the allegation that it did not authorize the counsel in the law firm of Judge Taylor, Ashiru and Co. to act on the judgment debtor's behalf, have permitted the court and the judgment creditor to believe that they were afforded fair hearing, as hearing notices were served. The counsel on record did not try to formally discontinue his appearance or withdraw the same, and his firm kept receiving hearing notices in the matter from the court without protest. Having made such representations, they cannot, with due respect, now be allowed to deny the truth that their conduct, omissions have impressed that they were afforded fair hearing. The actions of the judgment debtor counsel is binding on it. The law is well settled that when a party fails or neglects to utilize the opportunity afforded it by the court to put up his case, such party cannot later turn around to accuse the court of denial of fair hearing, or rather to be heard to complain of denial of fair hearing. See the case of EcoBank Nigeria PLC versus Moye, quoted in 2021, and also Bank PHP versus CBN, quoted in 2019, Gideon versus Sanusi, reported in 2023. Citations all fully supplied. The right to fair hearing is not the same as the right to be heard at all costs. It is not the duty of the court to force a party to be heard. The court is only obliged to prove a conjunctive environment and equal opportunities to parties to be heard. See the case of Mijim Yawa versus Balewa, quoted in 2022. Now, the defendant judgment debtor was afforded the opportunity to be heard and to present his own position in relation to the claims of the claimant judgment creditor. The judgment debtor, in utilizing the said opportunity, had a counsel to represent it. The counsel on the judgment debtor's behalf entered appearance, filed a statement of defense, which was later amended, only for the judgment debtor, with the applicants acting on his behalf, to attempt to lure the court to renounce the acts of his counsel emanating from the contractual relationship entered into prior to the appointment of the receiver manager. A party having benefited from a contractual relationship cannot be held later to complain that the contract was wrong. This is what the applicant seems to be doing. Furthermore, the applicant's application to set aside or vacate or annul any proceedings and garnish other NISI was brought way outside the period allowed by the rules of court to bring such applications. See Order 47, Rule 16 of the National Industrial Court of Nigeria, Civil Procedure Rules 2017, which requires such an application to be brought within 14 days after the order was made. Judgment was delivered in suit number NIC/LS/16/2017 on the 11th day of May 2022. The garnishee order NISI was granted or made on the 2nd day of November 2022. The applicant's application was filed on the 6th day of December 2022. There are no prayers in the said application seeking for extension of time to apply to set aside either the judgment or the garnishee order NISI. See the case of Malgui versus Gadazama, reported in 2000. Isong versus Omoren, reported in 2010. Davis versus Bill Pine Limited, reported in 2004. And also Williams versus Hope Rising Voluntary Funds Society, reported in 1982. This is fatal to the applicant's application, as he has not stated relevant or material facts that occasion the delay in bringing the application. Besides, it is common knowledge that garnishee proceedings are usually commenced with an application brought by a motionless party seeking the granting of a garnishee order NISI. The court, upon consideration of the application, where it grants the order, orders the garnishee or garnishees to appear in court to show cause, and that notice and the order be served on the judgment debtor. To argue, as the applicant's counsel has done, that the originating processes for the garnishee proceedings were not served on the applicant or garnishee, so it robs the court of jurisdiction. It beats my imagination. It is where the garnishee order NISI was not served at all on the judgment debtor, or was served outside 14 days, or for such number of days as permitted by the rules of court, that the judgment debtor may object to such irregularity. See Order 51, Rule 3.1 of the NICN Civil Procedure Rules, 2017. The applicant herein has not complained that the garnishee order NISI was not served on him, or that it was served on him outside the period allowed by the rules of court, nor has he stated under which law it is required that the motionless party commencing the garnishee proceedings be served on him. The issue of suppression of facts will also not avail the applicant, as the burden is on him who asserts to call evidence in support of his assertion. In all, it is a considered view of this court that it provided conducive environment and granted either parties equal opportunities to present their case before it, which they did for the most part. I therefore find and hold that the instant application lacks merit. The issue for determination is resolved in favor of the judgment creditor respondents. Learned applicants' counsel submission in support of the application are hereby discountenanced, and the applicant's application of 6th December 22 is hereby dismissed. I so find and I so hold. Ruling is entered accordingly.
As court pleases.
God please. We thank you for a well-detailed judgment. My Lord took his time. We are most obliged.
Very well. I'm glad to hear that. Thank you.
My Lord, we are grateful for the ruling.
Okay. Thank you. So as it is, that's the end of this particular matter. So it's John Sineda, isn't it?
No, apologies, my Lord. I'm not sure
it's Okay, yes.
We are to...
Let me see. They want to show ahead. This was the first one to show cause, and okay, this is the ruling on the application of the judgment debtor applicant. So it doesn't end the matter.
Yes.
Okay, when are we
So
coming back?
we need a date to come and finish up with the garnishing proceedings.
Yes. Give me the what the
October 24.
how do you stand on the 24th day of October?
My lord, it's not convenient.
Okay.
People get 25th or 23rd.
To November.
Okay. What do you say we go to November? When?
I go to November 7.
7th November, perhaps.
Okay, it's convenient.
Okay. How about you? Nene, how about you?
It's convenient, my lord.
Okay, 7th of November. Okay.
It's convenient,
Okay.
my lord.
Okay. So the matter is now adjourned to the 7th day of November 2023 to conclude these garnishing proceedings.
As God pleases.
Yes.
As the court pleases.
Yes. Absolutely. Yes, which one is? That's it.
Yes, madam.
Do you mean it? Nigerian University. I see. Okay then. Tell him to remove me from the radar.